My name is Bill Martin, and I'm the clerk of the Georgia Court of Appeals. And I want to thank Trish McCann and the good people at the Georgia Consumer Standards Council for asking me to come and speak to you today. The title of my talk is Maneuvering in the Court of Appeals. Before I came over, I looked in the dictionary, and there are several definitions for maneuvering: military, aeronautical. The one I thought that probably fit the context of our talk is a way of doing something with dexterity and skill. So that's what we're going to try to do today, is help you do something with dexterity and skill. I'd like you to write down this telephone number. It's 404 657 8352. That is my direct line. If you ever have a question about rules or procedures or how the court operates or anything else you want to ask me, do not hesitate to give me a call. If you think you've got your ox in a ditch and can't get it out, I'm an old rat in the barn. I've seen a lot of things, so some things we can do to help you. I'm going to give you my email address as well, and that is martinw@gaappeals.us, and you can email me your question if you prefer. Preliminarily, I'd just like to say I want to appreciate and thank all of you who are volunteering to help people who have been accused, and in your case, convicted of crimes in the state of Georgia. And the public defenders across the state do a wonderful job, but we're all being asked to do more with less in the public sector, and I'm sure it's very much so in the private sector. And under our Constitution, people accused of crimes are afforded certain constitutional rights, and it's necessary that they have attorneys who are willing to help them to protect those rights. I practiced much of my time. I did a lot of criminal law when I practiced, representing persons accused of crimes. Most of them were appointed. I kind of refer to them as life's losers, bless their hearts. They were too stupid to do anything with crime, and they were just terrible at crime. But the great thing about our system is somebody is not guilty until a jury says they're guilty and having found them beyond a reasonable doubt, or they admit their guilt in open court with enough cooperating evidence for the trial court to take that. I mean, I can admit to shooting Abraham Lincoln, but you can't cooperate, so the court couldn't take that plea. As I understand it, all of you will be doing appellate work for these accused people. Is that correct? Now, just a little show of hands. How many in here have had a criminal case in the Court of Appeals? Did I show your hand? And how many have just had any case in the Court of Appeals? Okay, so pretty much everybody's familiar how we operate up there. There are 4 ways to get cases into the Court of Appeals in Georgia. The first I'm going to talk about, and the most common, is a direct appeal. And that is initiated by filing the notice of appeal with the clerk of the trial court. 5-6-37 tells you what should be in that notice of appeal, the contents of the notice of appeal. 5-6-38 tells you the time frame for filing the notice of appeal. And then 5-6-34A lists those cases that are directly appealable. I'll talk about this in a minute. This is the tail end of a. Anybody here attend the appellate practice seminar in February, end of February? Well, this was the tail end of my talk there that I never got to. Ran out of time. But If you want to note a copy of the notice of appeal or a form of the notice of appeal, that's also in the code, 5-6-51. And basically what the notice of appeal must identify is the order that is being appealed. And make sure when you file your notice of appeal that you attach a certificate of service showing the complete name and mailing address of the prosecutor who will be in the case. If I don't have the complete name and mailing address, I can't docket the appeal because I can't send out the docketing notice. And don't put the district attorney's office in Fulton County because they've got, I don't know, 100. Or don't put the DA in Gwinnett County because I need a name. Obviously, I'm going to put Paul Howard. I'm going to put Danny Porter. If it's, but you know, those people are managing. You know, they're not. I know they go in the courtroom some, but you know, they have a lot of associates, if you will, that they're farming that work out. The notice of appeal must be filed in the trial court within 30 days of the date of the sentence, or if a motion for new trial is filed within 30 days from the order denying the motion for new trial. Sometimes you just go ahead and file the notice of appeal. So I'm not going to wait on the, I'm so mad at the judge, I'm not going to, you know, let the knucklehead. I'm going to go ahead and just file my notice of appeal. You can do that, but as a practical matter, this is what happens. You're having to wait on the transcript. So then you got to go back there and file a motion or get an order from the trial court granting you a 30-day extension to get your transcript in there. So it's just much easier just to go ahead and wait on your, you know, unless you maybe have a small transcript or something like that. One of the gentlemen toward the back asked about meeting with the clients. I think that's a good thing. I don't know if it's necessarily required, but I would certainly write the client and say, I am Bill Martin. I will be representing you on appeal. I will keep you informed as to the developments in the appeal. But you must understand this is not like the trial. That the issues be argued will be derived from the record and from the objections made and preserved in the trial court. Because I will tell you, I get these letters, I get prison, first thing I do, I try to get to the office about 7 o'clock in the morning, and I dictate my prisoner correspondence before we open at 8:30 and the phone start ringing, I can't get to it. And I understand, look, if I'm in the penitentiary, I'm hoping somebody out there cares about me. But, you know, they're going to want you to call them every day. They're going to want you to write them every day. They're going to want you to tell them everything's going to be okay. And you massage your client however you want to. But the point of the fact is, it's not necessary on the appeal, because what you have is a record that you're going to have to review. You're going to have to find out these objections that were made and overruled and have merits. You've got to see how the law applies to those. So there's really nothing else we can do. Okay, if there's a witness that should have been called and wasn't, well, that may then get back to your ineffective assistance argument. But pretty much everything that's in the record is what you've got to deal with. It's hard, very hard to carry the burden of newly discovered evidence. But anyway, just wanted to mention that because they will want you to hold their hands all the way through. You've got to file that notice of appeal timely or you deprive the court of jurisdiction. However, unlike civil, in criminal cases, you do have the right to file an out-of-time notice of appeal. So if there is some reason that the notice of appeal was not timely filed, you can file in the trial court a notice, an out-of-time notice of appeal. Just style an out-of-time notice of appeal, put it on Rule 9 side for a hearing, and then, you know, tell the judge why you're not able to file timely, And if the judge denies that, you can appeal that order. Most judges are going to grant it because the Supreme Court of the United States, and I don't have the site, but these folks from the Public Understanding Council can tell you, the Supreme Court of the United States has said every criminal defendant in this country has the right of his first level of appeal. And the Court of Appeals is going to be his first or her first level of appeal. So you've always got that out-of-time appeal if you weren't able to file the notice of appeal within 30 days. Direct appeals, when they come to Court of Appeals, they're docketed. We send out the docketing notices. They're assigned to a particular judge and a panel. We do not tell you the judge who has the case. You will have the panel or the division, the 3 judges on your docketing notice. Your docketing notice will tell you the briefing schedule. It will tell you if oral argument is requested and granted, when the oral argument will be, and will give you other important information. Since all of you are going to be representing appointed cases, please, when you file your brief, or if it's not in the record, if it's in the record, it's not a problem, but if it's not in the record, when you file your brief, put a copy of your order of appointment in there. Or if you don't have an order of appointment, just say, "Dear Bill, I am stating in my place that I was appointed by Judge so-and-so, whatever court, to represent this person on the appeal." Because there's a code section, 5-6-4, which says the clerk is prohibited from receiving a brief of the appellant without, in a criminal case, $80 filing fee or sufficient office affidavit or evidence of innocency in the record. If it's in the record, when we docket the case, when we get the record from the trial court, we'll go ahead and docket as part of the case. It won't be a problem. And if I got one from my old classmate, Grayson Lane from Brunswick this morning, and the application clerk came to see me and she said, I can't find the office affidavit. And I said, well, yeah, but look, it's the public defender's office, so that's okay. So before we can determine it's the public defender's office, we're not going to hold up your filing. Also, another way to appeal is discretionary applications. Now, there are certain cases in which the legislature has said that citizens of Georgia do not have the right of a direct appeal. They are set out in 5-6-35. There are 13 of them, and 12 of them are set out in 5-6-35. The 13th one is the Prisoner Litigation Reform Act of 1996, 42-12-1F2. Now that code section deals if you are incarcerated and want to file a civil suit or initiate a civil suit, that's what you got. If you initiated the trial court and you want to initiate the appeal, then you've got to follow that discretionary appeal. In criminal cases, the only thing you're going to have in discretionary is probation revocations, which probably are really civil, but we all treat them as criminal. And a denial of a motion for an extraordinary motion for new trial. Let's say you got this case and you think, whoa, look, there's some newly discovered evidence or something, and we have an extraordinary motion for new trial. If that's denied, that is appealed by discretionary application. Most of the others are going to be civil in nature. When you file a discretionary application with the Court of Appeals of Georgia, it must contain a stamp file copy of the order you are appealing. Without that, the court doesn't know if you filed timely. And the time frames are jurisdictional in applications. If you file your brief late, that's not, I mean, that may be sloppy or it may irritate or aggravate somebody, but it's not going to get the case dismissed. If you file that application for discretionary appeal or interlocutory appeal and it's late, then you deprive the Court of Appeals of jurisdiction here. And the Court of Appeals of Georgia does not have equity jurisdiction. Only the Supreme Court, the Superior Courts have equity jurisdiction in Georgia. The Supreme Court, they say, well, yeah, it should have filed, it's just not right, we'll wait here. The Court of Appeals does not have that flexibility.